This conference is the right event at the right time, and I congratulate the organizers on putting it together and making it happen, albeit a year later than originally planned, and in a format adapted to the constraints and difficulties which continue to affect us all. Throughout my 50 years as a practicing lawyer, I was constantly engaged in seeking the best practical balance in the hugely variable circumstances of an almost infinite variety of individuals and their personal characteristics, between autonomy and protection, in order best to meet their needs. Every time the questions were whether special measures were needed. If so, what measures? And if measures were already in place, did they need to be changed? Every time selecting from the range of measures available within my legal system and the scope for possible variability in the application of each. Over those decades, there has been huge variation and development in the measures available and in thinking about the fundamental principles that should guide us. Some measures varied fundamentally in successive rounds of law reform, albeit with the same descriptive label attached. New measures emerged. When, in more recent years, I became increasingly engaged with the picture across Europe and worldwide, I learned that this huge variability not only characterized the linear development of our subject in any one country, but also characterized the horizontal picture across our continent at any one point in time. Each of the comparative studies in which I have been involved has produced a mass of varied material. To do full justice to the 9 words of our conference title, comparatively across all the jurisdictions of Europe, would require a large volume, not a 30-minute presentation. What I shall try to do accordingly is to create and describe functional categories, the menus from which practicing lawyers endeavor to select, with an emphasis on that basic point that, comparing only 2 jurisdictions, particular measures that may have the same label and seem to have similar packaging will almost certainly have significant differences once you open the package and look at the detailed contents. That variability is multiplied across our continent, with further variabilities arising from reforms of hard law and developments in practice as to how the law is applied. That variability can become of acute importance when an existing measure established in one jurisdiction is imported from that jurisdiction into a receiving jurisdiction, and we seek recognition, operability, and enforceability in the receiving jurisdiction. Those issues have received increasing attention in recent years. There have been initiatives by the European Parliament, work by the European Commission, a project by European Law Institute, and the current work led by the Permanent Bureau of the Hague Conference on drafting a practical handbook on the operation of Hague Convention number 35 of 2000 on the international protection of adults. On terminology, I use the one general word, measure. It is interesting that Hague 35 uses measures of protection, also used in Council of Europe Recommendation 99.4, on principles concerning the legal protection of incapable adults. Whereas a decade later, Council of Europe Recommendation 2009-11 on principles concerning continuing powers of attorney and advance directives for incapacity emphasized the principles of autonomy and self-determination. And prior to that, the UN Convention on the Rights of Persons with Disabilities, the Disability Convention, refers to measures that relate to the exercise of legal capacity. There we have the two starting points of protection and autonomy, which in theory can be endlessly debated, but in practice need to be drawn in each individual case to meet at the point of appropriate balance for a particular adult in particular circumstances at a particular time. That earlier instruments sought to reach that point of optimum balance starting from protection, and the more recent ones starting from autonomy, marks a fundamental shift in emphasis that began well before the Disability Convention and has received huge impetus from that convention. It is a shift that is still driving processes of law reform, as well as influencing interpretation of existing law and of international instruments. So, let us look at the main broad categories of measures across our continent, the different techniques that may be found within each category, and some of the variabilities. Almost certainly, as you listen, some of you will think of some exceptions that qualify or even disrupt the scheme that I present. If so, do please tell me about them. There are three principal categories of measures, two of them divided into two subcategories. They are voluntary measures, which may be bilateral or unilateral, non-voluntary measures, which may be automatic or established by a court or other authority, and third-party measures. Relevant human rights principles indicate that priority should be given to rights to autonomy and self-determination, so that voluntary measures established by an adult should be preferred to non-voluntary measures created otherwise than by adults themselves. Relevant Council of Europe recommendations have developed from urging states to consider providing for voluntary measures. Thus, Principle 7 of Recommendation 99-4 on principles concerning the legal protection of incapable adults reads, consideration should be given to the need to provide for and regulate legal arrangements which a person who is still capable can take to provide for any subsequent incapacity. They have developed from urging them in such language to requiring them to promote self-determination by means of both bilateral and unilateral voluntary measures, requiring them. For example, Principle 1 of Recommendation 2009 on principles concerning continuing powers of attorney and advance directives for incapacity reads, 1, states should promote self-determination for capable adults in the event of their future incapacity by means of continuing powers of attorney and advance directives. 2, in accordance with the principles of self-determination and subsidiarity, states should consider giving those methods priority over other methods of protection. Likewise, Principle 14 of Recommendation 2014-2 on the promotion of human rights for older persons declares that member states should provide for legislation which allows older persons to regulate their affairs in the event that they are unable to express their instructions at a later stage. The terms voluntary measure and non-voluntary measures have generally superseded the former classifications of anticipatory measures and responsive measures. The change reflects an important shift in perceptions and values. Again, a change accelerated by the Disability Convention. Formerly, we had a binary world of capacity or incapacity, sanity or insanity, educability or ineducability, and so on. It became recognized that these extremes were the theoretical ends of a wide and diverse range of characteristics and capabilities, with no one completely capable or completely incapable. The shift in terminology recognizes the extent to which persons with relevant disabilities, including mental, intellectual, and sensory disabilities, may nevertheless themselves establish measures sufficient to meet their circumstances and needs, particularly if they are given adequate support to do so. A wide range of measures with varied terminology come within the general category of unilateral voluntary measures. They have descriptions such as advance directives, advance statements, advance decisions, advance healthcare decisions or directives, living wills, patient decrees, and others. And that's just in the English language. They are probably all encapsulated within the definition in Recommendation 2009-11, Principle 2.3, advance directives are instructions given or wishes made by a capable adult concerning issues that may arise in the event of his or her incapacity. This is supplemented by Principle 14. Advance directives may apply to health, welfare, and other personal matters, to economic and financial matters, and to the choice of a guardian, should one be appointed. As I found in my consultancy work for Council of Europe, as described in my report, Enabling Citizens to Plan for Incapacity, there is great variety across Europe in provision for advance directives. A general feature being that such provision is underdeveloped. According to the information provided to me by member states, at least at that time, there was nowhere any clear legislative provision maximizing the scope of self-determination by advance directives. Where they exist, they are often limited to healthcare matters and frequently to particular aspects of healthcare only. Other techniques, such as gifts, are sometimes used for the purpose of making provision for incapacity. They can obviously be hazardous. Bilateral voluntary measures are well defined in Recommendation 2009-11 to cover all powers of attorney for incapacity. Principle 2 contains the key definitions. A continuing power of attorney is a mandate given by a capable adult with the purpose that it shall remain in force or enter into force in the event of the grantor's incapacity. Here again, there is varied terminology. Power of attorney and private mandate are probably the most frequent, but others include enduring, lasting, continuing, welfare, or durable powers of attorney. And again, that's only in the English language. And I shall not take time listing all the terms that I have come across in other languages. When I was in China, I was told that the concept of such a power of attorney was unknown there. But then I was told about self-determined guardianship, which would appear to fall within that Council of Europe definition. However, China is not in Europe, and we are concerned with Europe. I again found much variability across Europe and much variability in amounts of use, even where powers of attorney are available. Unsurprisingly, there seems to be much lower use in states that have ex lege representation compared with otherwise similar states which do not. However, watch carefully for apparent differences between states which influence the statistics, such as states where relevant documents are registered at time of granting and states where they are registered only when they come into operation. There is variability for almost all of the key features, including as to whether joint and substitute attorneys are possible, whether it is possible or even mandatory to have a supervising attorney, formalities at time of granting, certification and registration, limitation on the powers that may be conferred, and safeguards and controls during operation. The variabilities often reflect different political judgments on the appropriate balance between autonomy and protection, from light touch regimes, maximizing autonomy, but of course, also maximizing risk, and more heavily regulated regimes, maximizing protection, but limiting flexibility and individual choices and judgments. There are other bilateral techniques, often very simple ones, such as setting up a joint bank account, under which one account holder can continue to operate the account, notwithstanding impairment of the capacity of the other. This usually requires express facilitation in legislation to reverse the presumption that incapacity of either account holder terminates the mandate to operate the account. Largely underdeveloped are provisions maximizing support for the exercise of legal capacity in the very common situations of variable, fluctuating, or gradually increasing impairments of capacity, principally by including provisions for support and co-decision making operable independent of questions of capacity. Typically, the same person is appointed supporter, co-decision maker, and attorney. As supporter, a key power is to have access to data, including personal and confidential data. Under co-decision making, capacity is irrelevant. If the adult is deemed capable, it is the valid act of the adult. Otherwise, it is the authorized act of the co-decision maker. Either way, it is valid and there is no need for further inquiry. If need be, the attorney acts alone under the powers conferred. Where these arrangements are contained in the same document, they permit compliance with the Disability Convention requirement for support for the exercise of legal capacity through transitions to greater or lesser degrees of impairment of relevant capabilities. The interplay of advanced directives and powers of attorney, whatever the terminology, and for using both in combination, offers scope also still largely undeveloped. Thus, an adult would like to grant a power of attorney, but does not adequately trust members of their own family, does not know whom to appoint, accepts that at some future date a guardian may be appointed, but is quite clear about who should not be appointed guardian. That adult has clear views about how matters should be managed. These are accordingly set out in a unilateral voluntary measure that is designed to be binding, as are the statements as to who should not be given a role in the matter. Alternatively, an adult may have an obvious choice for attorney, hopes that the attorney will outlive them while still able to act as such, but has no obvious alternative to be appointed substitute. The adult accordingly issues both bilateral and unilateral voluntary measures in substantially the same terms, again drafted with the intention that the unilateral measure be binding, which will not cause problems to the attorney if effectively mirroring the power of attorney document, but will cover the situation if the attorney dies or otherwise ceases to act. The advantages of unilateral measures, however, go further because they are addressed to the world. The world could cover carers, medical practitioners, providers of other services, as well as anyone appointed to any particular role to act on behalf of the grantor. Non-voluntary measures are those put in place by a court or other authority or designated professional, or by automatic operation of law. Taking automatic measures first, there is a clear divide regarding so-called ex lege representation. Some states have that concept, some do not. Among those that have it, the scope is varied, sometimes limited to healthcare matters only. Where the concept exists, one needs to know how incapacity to trigger such representation is defined and evidenced, so as to achieve recognition and operability. Who is the representative? What they can and cannot decide, in what circumstances, how that authority ends, and how the ending is evidenced and made effective. Apart from ex lege representation, the principal measure in many states is, again, varied in content and terminology, including in English, guardianship, curatorship, tutorship, conservatorship, and others. There can be measures for intervention where an adult is deemed to be at risk, appointments for receiving and administering particular assets, such as state benefits, and a range of situations in which courts and/or administrative authorities have powers to intervene by giving instructions or directions to people operating or concerned in the operating of various specified types of measure, to revoke the measure as a whole, or particular powers conferred, or the appointment of a particular individual, to determine disputes among persons with an interest, between appointees and persons with an interest, or between joint appointees, and so forth. They also cover measures addressed to functions under other legislation, such as health, and in particular mental health legislation. Variability extends not only to the range of measures and their characteristics, but more subtly to which might be the preferred measure in any particular situation. Third-party measures are measures established by the provider of funds or assets, including individuals by lifetime gift or provision arising upon or following death. For administration for a beneficiary with limitations of capabilities, or administration should such limitations arise. Examples include various types of trust: discretionary trust, disabled persons trust, and so on. Again, with much variability across our continent. In some jurisdictions, much used and highly developed, but in others, little known and little used, or even not available at all. Beware that the categories of measures that I have described cannot be put in neat, self-contained boxes. One category may have characteristics of another, such as where it is possible for adults themselves to apply for appointment of guardians to themselves, or where a court order facilitates establishment of a trust. In conclusion, it follows from all that I have said that great care is needed in addressing apparent similarities between one jurisdiction and another. Drill down, and similarities on the surface may well conceal significant underlying differences. The task of doing so can be fascinating and rewarding. Thank you for listening. I hope that this broad overview might be helpful.